interest, successors, and assigns, as well as all authorized or unauthorized users or beneficiaries of services or devices under this or prior agreements between us. Notwithstanding the foregoing, either party may bring an individual action in small claims court. This arbitration agreement does not preclude you from bringing issues to the attention of federal, state, or local agencies, including, for example, the Federal Communications Commission. Such agencies can, if the law allows, seek relief against us on your behalf. You agree that, by entering into this agreement, you and AT&T are each waiving the right to a trial by jury or to participate in a class action. This agreement evidences a transaction in interstate commerce, and thus the Federal Arbitration Act governs interpretation and enforcement of this provision. This arbitration provision shall survive termination of this agreement. 2. A party who intends to seek arbitration must first send to the other, by certified mail, a written notice of dispute notice. The notice to AT&T should be addressed to Office for Dispute Resolution, AT&T, 1025 Lenox Park Boulevard, Atlanta, GA30319, notice address. The notice must further describe the nature and basis of the claim or dispute, and b. set forth the specific relief sought for demand. If AT&T and you do not reach an agreement to resolve the claim within 30 days after the notice is received, you or AT&T may commence an arbitration proceeding. During the arbitration, the amount of any settlement offer made by AT&T or you shall not be disclosed to the arbitrator until after the arbitrator determines the amount, if any, to which you or AT&T is entitled. You may download or copy a form notice and a form to initiate arbitration at att.com arbitration forms. 3. After AT&T receives notice at the notice address that you have commenced arbitration, it will promptly reimburse you for your payment of the filing fee. Unless your claim is for greater than $75,000. The filing fee currently is $200 for claims under $10,000, but is subject to change by the arbitration provider. If you are unable to pay this fee, AT&T will pay it directly upon receiving a written request at the notice address. The arbitration will be governed by the commercial arbitration rules and the supplementary procedures for consumer-related disputes are collectively AAA rules of the American Arbitration Association, AAA, as modified by this agreement, and will be administered by the AAA. The AAA rules are available online at ar.org by calling the AAA at 1-800-778-7879 or by writing to the notice address. You may obtain information that is designed for non-lawyers about the arbitration process at att.com arbitration information. The arbitrator is bound by the terms of this agreement. All issues are for the arbitrator to decide, except that issues relating to the scope and enforceability of the arbitration provision are for the court to decide. Unless AT&T and you agree otherwise, any arbitration hearings will take place in the county or parish of your billing address. If your claim is for $10,000 or less, we agree that you may choose whether the arbitration will be conducted solely on the basis of documents submitted to the arbitrator through a telephonic hearing, or by an in-person hearing as established by the AAA rules. If your claim exceeds $10,000, the right to a hearing will be determined by the AAA rules. Regardless of the manner in which the arbitration is conducted, the arbitrator shall issue a reasoned written decision sufficient to explain the essential findings and conclusions on which the award is based. Except as otherwise provided for herein, AT&T will pay all AAA filing, administration, and arbitrator fees for any arbitration initiated in accordance with the notice requirements above. If, however, the arbitrator finds that either the substance of your claim or the relief sought in the demand is frivolous or brought for an improper purpose as measured by the standards set forth in Federal Rule of Civil Procedure 11b, then the payment of all such fees will be governed by the AAA rules. In such case, you agree to reimburse AT&T for all monies previously disbursed by it that are otherwise your obligation to pay under the AAA rules. In addition, if you initiate an arbitration in which you seek more than $75,000 in damages, the payment of these fees will be governed by the AAA rules. 4. If, after finding in your favor in any respect on the merits of your claim, the arbitrator issues you an award that is greater than the value of AT&T's last written settlement offer made before an arbitrator was selected, then AT&T will pay you the amount of the award or $10,000 for the alternative payment, whichever is greater, and pay your attorney, if any, twice the amount of attorney's fees, and reimburse any expenses, including expert witness fees and costs, that your attorney reasonably accrues for investigating, preparing, and pursuing your claim in arbitration, the attorney premium. If AT&T did not make a written offer to settle the dispute before an arbitrator was selected, you and your attorney will be entitled to receive the alternative payment and the attorney premium, respectively, if the arbitrator awards you any relief on the merits. The arbitrator may make rulings and resolve disputes as to the payment and reimbursement of fees, expenses, and the alternative payment and the attorney premium at any time during the proceeding and upon request from either party made within 14 days of the arbitrator's ruling on the merits. 5. The right to attorney's fees and expenses discussed in paragraph 4 supplements any right to attorney's fees and expenses you may have under applicable law. Thus, if you would be entitled to a larger amount under the applicable law, this provision does not preclude the arbitrator from awarding you that amount. However, you may not recover duplicative awards of attorney's fees or costs. Although under some laws AT&T may have a right to an award of attorney's fees and expenses if it prevails in an arbitration, AT&T agrees that it will not seek such an award. 6. The arbitrator may award declaratory or injunctive relief only in favor of the individual party seeking relief, and only to the extent necessary to provide relief warranted by that party's individual claim. You and AT&T agree that each may bring claims against the other only in your or its individual capacity, and not as a plaintiff or class member in any purported class or representative proceeding. Further, unless both you and AT&T agree otherwise, the arbitrator may not consolidate more than one person's claims, and may not otherwise preside over any form of a representative or class proceeding. If this specific provision is found to be unenforceable, then the entirety of this arbitration provision shall be null and void. 7. Notwithstanding any provision in this agreement to the contrary, we agree that if AT&T makes any future change to this arbitration provision other than a change to the notice address during your service commitment, you may reject any such change by sending us written notice within 30 days of the change. 9/29/2020 Terms of Service, Legal Policy Center, AT&T. https://www.att.com/legal/terms.wireless-customer-agreement.html6:19. To the arbitration notice address provided above. By rejecting any future change, you are agreeing that you will arbitrate any dispute between us in accordance with the language of this provision. 2.3 Puerto Rico customers. For Puerto Rico customers, references to a small claims court in sections 2.1 and 2.2 should be understood to mean the Puerto Rico Telecommunications Regulatory Board. 3.0 Terms relating to your device and content. 3.1 Your device. Your device must be compatible with, and not interfere with, our services, and must comply with all applicable laws, rules, and regulations. We may periodically program your device remotely with system settings for roaming service to direct your device to use network services most appropriate for your typical usage and other features that cannot be changed manually. Some device manufacturers will no longer preload certain applications into the device memory. As a result, AT&T may remotely preload certain applications to your device at activation and periodically update those applications. You can delete any application that AT&T remotely preloads on your device. You agree that you won't make any modifications to your equipment or its programming to enable the equipment to operate on any other system. AT&T may, at its sole and absolute discretion, modify the programming to enable the operation of the equipment on other systems. If you bought a device from AT&T, it has been programmed with a SIM lock which will prevent it from operating with other compatible wireless telephone carrier services. If you wish to use this device with the service of another wireless telephone carrier, AT&T will unlock your device if